Greetings, this is Erick Widman from Passage Immigration Law. Welcome to another live Q&A where we answer your immigration questions. Thanks so much for joining us and for submitting really excellent questions again this week. So we're going to start things off with kind of a sad question, but an important one. Will I lose my resident status if I divorce my husband? So sorry about that you're going through, and you have a green card currently, as you noted, and you most likely received your green card through marriage to your husband. So that's an assumption I'm making here. So you likely married a U.S. citizen, and you adjusted status or received a green card through an immigrant visa through your U.S. citizen husband, or you could be a permanent resident, but your spouse, your husband, was the petitioner, you were the beneficiary, you became a permanent resident, and if you had been married less than 2 years when you applied and received that green card, then you will have received a 2-year green card as opposed to a 10-year green card. And so if you have a 2-year green card, you're required to apply for a 10-year green card at the end of that 2-year period. You have to remove conditions, and that's through filing form I-751. The normal standard process, the default is that you do a joint filing with you and your husband to apply for your 10-year green card. And if you are in the process of a divorce, you would have to do a waiver filing, or if you are divorced, you have to do a waiver filing for your I-751 removal of conditions. And part of the process, one of the requirements, is that the divorce is completed in order to get your 10-year green card. So sometimes you can start the process and you always have to file the 751 even if the divorce is not finalized. USCIS will issue a request for evidence and often give you some time to get the divorce decree issued and finalized from the judge in whatever state you live in. So you have to renew your 2-year green card to get a 10-year green card in order to stay in the US and maintain your permanent resident status. And you would have to have a waiver approved and show that you had a genuine relationship at the beginning of your marriage, but things sadly fell apart. You can still get your 10-year green card approved in that situation, but you have to show lots of evidence of your genuine marriage. And we often do a sworn declaration with evidence showing what went wrong and that you had every intent to stay in this marriage if X, Y, and Z didn't happen. Now, if you already had a 10-year green card, and you have effectively that LPR, lawful permanent resident status, that's not conditional permanent resident status, you are not going to be affected in that way in terms of your immigration status if you get divorced. So if you already have a 10-year green card and you get divorced, you don't need to do anything special. There's no waiver requirement when you go to renew your 10-year green card, and you can certainly naturalize if you want to, but that would be at a 5-year mark as opposed to a 3-year mark for the time period required to become a U.S. citizen. You can naturalize faster in a 3-year time frame instead of 5 when you're married to a U.S. citizen. But if you're divorced, you have to go with a 5-year time frame to naturalize. All right, great question. And we trust things will work out with you and your green card. Okay, next question. I resigned from my job, and the employer is the reason why I'm in the US. If I apply to another company, should I go back first to my home country? So there's a lot of conditional, it depends type of issues for you. We would need more information to correctly, effectively answer this. But with employment-based immigration status, usually there's a brief grace period, but then you have to get a new immigration status set up through a new position. Sometimes an H-1B transfer could be the basis for it. It depends on the type of employment-based visa that you have. The safest thing is to leave and then have the consulate handle the issuance of your new visa or the transfer. You can do that outside the US. You don't want any unlawful presence. And so it really depends on the type of visa, the new position. You got to make sure that even with a transfer, it qualifies and meets all the necessary criteria. So the safest thing to do is leave and not accrue any unlawful presence. But in some cases, you are able to stay. It depends. Definitely consult with us or another good immigration law firm. We have an expert business immigration attorney at our firm you can speak with. All right. Here's the next question. My wife and I are US citizens, but we're planning to go back to the Philippines. Can my son bring his family to the US and apply for their citizenship? Okay, that's great. So you are US citizens of Filipino heritage, and you want to go back to the Philippines, and eventually you're hoping your son and his family immigrate to the US and apply for citizenship eventually. Okay, so as US citizens, you can petition for your son and his dependents, those derivative beneficiaries. So the key document to look at to determine the time frame for this, because it is a long time frame, it's called the Visa Bulletin. And the Visa Bulletin for Filipinos shows an especially long wait time, unfortunately. So even though you're US citizens, your son, if he's presumably over 21, because he's married and has some kids, that means that he is in a Visa Bulletin preference category called F3. F is in Frank. And I've got the Visa Bulletin pulled up right here for the latest month. And the US State Department issues an updated Visa Bulletin monthly. And so this shows the priority date and the cutoff time for everyone who's applied for a visa or wants to apply for a visa. It shows the likely wait period, but it primarily looks backwards to show how long the wait is. If you filed for a visa, you filed a petition, and the cutoff date that is listed for your case. The priority date means that the applicants who filed after the date your petition was filed are cut off from eligibility. And so, for example, for you, the F3 category for Filipinos shows that the cutoff date is June 8th, 2002. And if you filed before that date, your visa number, your petition is current, and you can proceed with applying for an immigrant visa. But for those who have petitioned after that date, you have to wait. You're cut off from eligibility, from availability. And so an approximation, it can change. It can move forward and move backwards. An approximation is that it can take roughly 20 years for your kids, for your son and his family to be eligible to get an immigrant visa, come to the US, and then another 5 years after that before they can become citizens. But first big step is getting them here and getting them work authorized and getting them green cards. And right now, it's an especially long wait. There could be some other avenues, employment-based or otherwise, that they should pursue that would be faster. But the quick answer to your question is look at the Visa Bulletin, check out the time frame there for the F3 category, and then pursue some other options. And sometimes family, you could look at student visas, employment-based visas, investment visas. There are options out there. Thank you so much, everybody, for tuning in. It's always a pleasure to do this. Look forward to seeing you next week, and take care.